Well, welcome back to the hot seat. I'm delighted today to be joined by Jemma Garside from Kingsley Napley. Welcome, Jemma.
Thank you.
So nice to see you and to talk to you today. You're part of the private client team at Kingsley Napley, but specialised in court of protection work. Perhaps you could tell us a little bit more about your client base and role at the firm.
So I'm a solicitor in the Court of Protection team. We specialise in assisting clients who do not have the mental capacity to make decisions about their property and affairs or their health and welfare. So that might be by reason of a brain injury, or they may have a health condition such as dementia, which means that they are no longer able to consider the factors that are relevant to decision making, and therefore they need somebody else to do that on their behalf.
And court of protection work is extremely specialised. I mean, perhaps you could talk us through some of the different actors, I suppose, in this space, some of the different roles that might be played by different parts of the court, or just to set out for intermediaries dealing with private wealth clients, but not from the specialist area.
Yes, absolutely. So the Mental Capacity Act was brought in 2005, and that allowed for the creation of deputyships as well as lasting powers of attorney. So in general, those are the two different factors at play here in the Court of Protection. The key difference is that with an attorney, the person concerned will have made that decision at a time when they did have capacity to make a decision to execute a lasting power of attorney. So they have chosen a particular person with the foresight that one day they may not be able to make decisions for themselves in the future, and therefore they've identified a person that they trust, or in fact people, and they've appointed them. Whereas with a deputyship, this will happen after a person has lost capacity, and therefore the court has to make that decision as to who is the appropriate person to become the decision maker.
So for a power of attorney, for say a business owner or someone who's creating wealth, it might be more obvious that they need to take these steps because they have obvious assets that they know will need decisions to be made about them. Do you see that a business owner or family of wealth prioritising putting this kind of planning in place?
Yes, absolutely. Because of the complexity of their affairs, they need to choose somebody who has the skills and experience to take on their business or estate, so to speak.
And within the power of attorney, there's different decisions that can be made on how people's affairs are managed and looked after. Perhaps you could explain a little bit more about that.
Yes, so there's two types of powers of attorney. There's one for property and affairs and one for health and welfare. So they're two separate instruments that a person would execute. You can also put very specific instructions in there as to how you may want your decisions to be made on your behalf. So the attorney must follow those. There's also a very helpful tool in there in that you can choose a replacement attorney. So say for some reason the person you've appointed is not able to carry out that role, you can make provision for somebody else to fill in.
And what about if there's a kind of international component? Is there difficulty if there's family members abroad who might want to make decisions? Is it possible to try and make allowances for that?
It is. It is possible to have an attorney or even a deputy who's based abroad. But there are complications with that, and it's probably more helpful to perhaps maybe think of having two people to be your attorney. So you could have one person who is here in the UK and on the ground, so to speak, and then have the other person who's abroad who can chip in and give ideas when required.
Do you find that other professionals around high net worth clients, like financial advisors, have a good grasp of this area? Do they table this with clients and perhaps bring them to your attention and come meet to get some advice on it, because they acknowledge that this area is complex but relevant for them if they're going to go on managing that client's financial affairs over the long term?
Yes, absolutely, and they need to be sure that, obviously with the regulations that they have to abide by, they need to be sure that they are exercising their authority correctly. So I think it's become more and more prevalent. Obviously we have an ageing population. It's becoming more on people's radar that this needs to be in place for people. So yes, we are seeing more and more that the wider network are becoming more aware.
And what's the difference between having a professional or a layperson making these decisions with you on your behalf?
Well, essentially, the biggest factor here is cost. So if you appoint a professional, you can make provision for them to charge for their services and their advice. And the same with a professional deputy. If the court appoints, say, a solicitor to act on behalf of another person, they are permitted to charge for their professional fees for what they have done. With a layperson, they're not permitted to charge, but what they can do is claim their reasonable expenses. Say, for example, they've had to travel long distances, then they can charge for that.
It's a lot for a layperson to take on, isn't it? It's a big responsibility. It's like doing an estate, asking someone to prepare an estate rather than a professional.
Absolutely, and particularly the initial work, it can be a full-time job for people. So it's a huge ask, and particularly for a layperson, like I said before, if they didn't have the necessary skills, they then have to look within their own network to get help to work out what they need to do.
And what about documenting the decision process? I mean, I imagine if you have lay people involved, it's even more complicated, as it were, because they're not as familiar with the process, but perhaps tell us a little bit more about decision-making in general processes.
Yeah, so with a deputy, they're required to report to the Office of the Public Guardian on an annual basis, and they are required to include in their report the decisions that they've made, key decisions that they've made. And when they're making a decision, they have to do that in a person's best interests. And that's a legal requirement, and there's a criteria that has to be followed. So in summary, what they need to do is think about what that person would have done before they lost capacity, and what their wishes and feelings are, as well as the views of others that are involved in their lives, such as family members. And attorneys have to do the same thing. They don't necessarily have to record their decisions. They don't have to report to the Office of the Public Guardian annually. But we would advise that they do that, because if they are ever subject to scrutiny, then they need to show the process that they followed when making decisions.
And the deputy would have an oversight also over like the financial affairs, so making sure that if there's a pot of assets to be managed, that will be done appropriately. I mean, that's quite a complicated job, isn't it, for the deputy? But I imagine that's where they use experience, use trusted partners. I mean, particularly where there's a lot of financial, assets at stake that need to be managed carefully. How does that tend to work? Yeah,
so the deputyship order, there's a general provision that's usually included in there, which allows the deputy to appoint a financial advisor. It must be somebody who's regulated, but they are permitted to appoint a financial advisor. And that's quite critical, because then they can look at things like cash flow planning, working out what the money is going to be needed for when, what other expenditure might come up in the future. So there's a lot of planning involved, and so the help of others and the advice of others is pretty critical.
And what about decisions like gifting? The deputy has oversight on things like that. How is that documented? How does it work?
Yeah, absolutely. So with gifts, there are quite strict rules about how a gift must be given. So the Office of the Public Guardian, who supervises both deputies and attorneys, they produce some really helpful guidance which explains what has to happen with gifts. But in general terms, they really must only be on customary occasions or to charities. And the most critical part of the gift is that it has to be reasonable and it has to be affordable to the person concerned. So if a deputy or attorney is thinking of making a gift that is pretty large when considering the size of the estate, it may be for very good reasons, tax reasons, or it's a very close family member. What they would be advised to do in those circumstances is apply to the Court of Protection for permission to make that gift. Anything beyond something which is just a small gift, really, one should really go to the court for authority. And do you work with clients sort of across the country, or where is it more London centric, or what determines when you get involved? Yes, our clients are all over the country.
Yeah.
We tend to have a few more in London because we are here. But yeah, we can assist anyone, anywhere.
And do you get referrals from other parts of Kingsley Napley? I mean, obviously within the private client team, they might be focused in certain colleagues or other departments. Does it tend to come up, say, from the corporate team or others, people doing work can actually bring you in to look at areas like this?
Yes, absolutely. We're a very collaborative firm. So say, for example, our family team, we work very closely with them on a number of cases, immigration. We have clients that come through our employment team, and particularly our clinical negligence team. So they will be assisting clients in obtaining a large compensation settlement. And
so that's like the litigation element to arrive at the sum that then.
So once they have the sum,
right,
we can step in and help them. And in those circumstances, they may have capacity to manage their affairs, but they want an extra layer of support. So we can help them with a personal injury trust, which is very, very similar. But it means that they have a professional helping decisions, making sure that money can last their lifetime.
So things like immigration is slightly surprising, but I suppose is it where there's a case of if someone's moving to the UK with wealth, they no doubt update a will and they look at this at the same time. Is that sort of the ethos often?
Yes, and they may also have a family member that is perhaps unwell and they have questions relating to that. So it's really helpful that they can actually say, oh, well, Gemma's over there, she can pick up the phone and advise.
Great. And so what about future developments in your field?
Well, I think the law is always developing. So the Court of Protection recently brought out a judgment which brought some more restrictions for deputies, or perhaps we would say they clarified them in terms of taking advice and commencing litigation on behalf of someone. So say, for example, somebody has a business, they owe a debt, a case is brought against them. We always would have thought that the deputy could act for them and fight the case. However, that has changed and they now have to do more to get authority to do that. So there are challenges ahead in dealing with these changes, and we may see more changes come.
Okay, fantastic. Well, look, Gemma, thank you for talking to me today, and we look forward to sharing this interview.
Thank you.